once again the Right Honorable Speaker, Alban Subana Bagbin, the Honorable Chief Justice, past presidents of the Bar, the executives of the Ghana Bar Association, as well as current members of the Supreme Court and retired justices of the Supreme Court. Our topic for today is the Supreme Court in the life of the 1992 Constitution, taking stock and looking forward. It is a singular honor and one I do not take lightly to chair this third lecture in the series convened to commemorate 150 years of the Supreme Court of Ghana. We are assembled here in Accra at the seat of this venerable institution, that's the law school, to continue a national conversation which at each sitting has deepened our appreciation of the course place in the life of the Republic of Ghana. The first lecture traced the course institutional journey over a century and a half in its trials, its triumphs, and the quiet fortitude by which it has weathered the turns of our national history. The second considered the relationship between the Supreme Court and the venerable institution of chieftaincy, one deeply woven into the fabric of our constitutional order. This progression is both deliberate and instructive. From institution to tradition, and now to constitutional meaning, the lecture series has moved steadily towards the central constitutional inquiry of how the Supreme Court has shaped and must continue to shape Ghana's constitutional history and destiny. Today, therefore, we turn the lens inward upon the Constitution itself. It is now some 34 years since the people of Ghana, by their sovereign will, gave unto themselves the 1992 Constitution, a document not merely of law but of national aspiration, forged in the resolve that our journey as a republic should remain anchored in the rule of law, the separation of powers, and the protection of fundamental human rights. It is fitting then that this lecture should invite us to reflect with candor and with hope upon the topic, the Supreme Court in the life of the 1992 Constitution, taking stock and looking forward, drawn from the wider anniversary theme, the Supreme Court at 150 years, honoring the past, celebrating the present, and defining the future. To take stock is to render an honest account of the landmark judgments by which the Supreme Court has given life and force to the text of our Constitution, of the moments when it has stood unflinching as guardian of the separation of powers and protector of our fundamental liberties, and in the spirit of true scholarship of those moments that invite reflection, critique, and reform. To look forward is to ask the harder question, what must the Supreme Court, and by extension the judiciary as a whole, become if it is to serve the Ghana of the next 50 years with the same fidelity with which it has served the Ghana of the past 3.5 decades. These and many more are not questions for the faint of purpose or for the faint-hearted. They demand intellectual honesty, institutional humility, and unwavering commitment to the constitutional project our forebears entrusted to us. It is therefore most fitting that we have with us today a speaker eminently qualified to guide us through this reflection. The chairman for the function has already laid the basis for the quality of the speaker, the Right Honorable Speaker. At this juncture, I wish I'd be permitted as chairman to express my profound gratitude to my Lord the Chief Justice and the chairman of the organizing committee of the celebrations and all its members for the devoted effort that has carried us thus far in this commemorative journey. As we listen today, may we do so not merely in celebration of an illustrious past, but in solemn recognition of the responsibility that history now places upon us. Let this anniversary summon the bench, the bar, our scholars, and the people of Ghana to renew our common covenant, the Constitution, to defend its supremacy, deepen public confidence in justice, and ensure that the Supreme Court remains for generations to come a steadfast guardian of liberty, legality, and democratic order. With that charge, and with confidence in the enduring promise of our republic, I invite us now to give our fullest attention to the lecture by the Right Honorable Speaker, who I dare say is best suited to deliver this third in the series. Thank you.
Thank you so much, my Lord Justice Doche. Thank you so much. Let's appreciate them. Thank you. Thank you so much. We shall continue by having brief remarks from the President of the Greater Accra branch of the GBA. Let's appreciate her.
Mr. Chairperson, the Right Honorable Speaker of Parliament, my Lord the Chief Justice, the Honorable Attorney General, all protocols duly observed. Good morning. A century and a half of the Supreme Court of Ghana. This is not simply an anniversary. It's a pilgrimage through time towards building an institution that is the pivot of our constitutional democracy. The theme, honoring the past, celebrating the present, and defining the future, invites us to reflect on our role in history, our commitment today, and our fervor for the future. Strikingly, the Greater Accra Regional Bar is hosting its annual conference under the theme, 150 Years of Ghana's Legal Evolution, Transforming the Profession and Driving its Future with Industry. The synergy between these themes is a testament to the greatness in our collective thinking. I am deeply honored as the President of the Regional Bar to share remarks on this historic milestone. When I was asked to speak, I turned to a treasured compass, Kojo Benti-Inchil's seminal article on the regulation of legal practice from 1853 to 2018. He captures vividly the condescension of colonial masters towards native lawyers and shares the imagery of this disdain in the words of Governor Strahan. Thus, there's a class of persons who, without property or position, possess a smattering of English, and with an ink glass, a few sheets of paper, and decayed European clothes, impose pretensions upon the ignorant natives. From that history dripping with contempt, through repeated attempts to restrict enrollment, we moved from just 52 lawyers enrolled between 1877 and 1897 to over 9,000 lawyers today. Today, we honor the generations of judges who resisted convenience in favor of conscience. We honor lawyers who stood sometimes at great personal cost for clients who had no other voice. We honor the founding justices who built our jurisprudence from first principles. We honor those who sat through political upheaval and chose fidelity to the Constitution over popular opinion. And we honor the countless members of the bar who treated every case, however small, as a matter of justice itself. Their legacy is not etched only in law reports. It lives in the difference they made. Today, we celebrate an institution that has embraced technology and reform while never compromising on rigor. We celebrate a bar that renews itself, welcoming new lawyers with fresh perspectives while grounding them in the non-negotiable disciplines of preparation, integrity, and ethics. And we celebrate something less tangible but more important, the robust yet respectful relationship between bench and bar. We do not always agree, and we should not always agree, but we share an unshakable commitment to due process, the rule of law, and the dignity of every person who seeks justice. That bond is the bedrock of public confidence. Anniversaries are portals to the future. They compel us to ask, what kind of court and what kind of bar do we intend to leave behind? We are already living the next 150 years. We'll be tested in ways the founders could scarcely imagine. Artificial intelligence, climate and cross-border disputes, a citizenry more informed, more vocal, and rightly more demanding of access to justice for all, not merely the privileged few. As the bar, we commit to being partners in that future. We commit to mentoring the next generation and championing access to justice. We stand with the judiciary in the shared task of keeping faith with the Constitution. Today, we do not only celebrate 150 years of the Supreme Court, we recommit ourselves to its purpose. Together with the judiciary, we will co-author the next chapter of the Supreme Court in the language of fairness, of courage, and unwavering fidelity to the law. Thank you very much for your kind attention.
Please keep applauding. You know, the applause is the only thing you will do here without the leave of the courts. Not even the Supreme Court of 150 years. You don't need leave to applaud. So please do applaud when our speakers come up and deliver the addresses in the manner they have done so far. I'd like to acknowledge a few people, and in no particular order, please. I'd like to acknowledge those of the Office of the Speaker of Parliament, the Honorable Joseph Nabu, Anthony Jakum, and Charles Ayamdo, anti-corruption advisor. Thank you all very much for being here with the speaker. The Greater Accra Regional Coordinating Council. Of course, the minister is here, but Reverend Harini Patai, Chief Director, thank you for being here. Please, let's have you acknowledge us as we acknowledge you. Also, the leadership and members of the Ghana Bar Association. Of course, you just heard Isabel Boateng, the Greater Accra President. Thank you. Andrew Appiah-Osei, Vice President, Greater Accra Bar. Agbesi Jakwasu is the immediate past President of the Greater Accra Bar. Joel Anoafari, the Secretary. All of you for being here. Thank you very much. The deans, heads of department and faculty members from academia, University of Ghana School of Law, Professor Atuduri Atupari, thank you very much for being here. From GIMPA, Nana Frakuma Bochio, the registrar, and Desmond Israel. Central University Law School, Professor Kenneth Ajumanatefa, and Samuel Echiahini Boedu, thank you very much for being here. From the Pentecost University Faculty of Law, Jifa Tamaklo, and the King's College Faculty of Law, Professor H.H. Mensah, the Dean, Frank Boafo, Abraham Yao, and Samuel Osei at Accra. Thank you all for being here. We'll continue the acknowledgements in no particular order, as I said earlier. At this juncture, we would like to welcome for her remarks the Greater Accra Regional Minister, the Honorable Linda Obrinwa Akwele Oklu. Please put your hands together for her.
Right, Honorable Speaker of Parliament, my Lord and the Chief Justice, colleagues, ministers of state present, members of the Judicial Council, Justice of the Supreme Court, Madam Chairperson of the Electoral Commission, Justice of the Court of Appeal, distinguished guests, ladies and gentlemen. My Lord, the Chief Justice, Justice of the Supreme Court, distinguished guests, ladies and gentlemen, institutions do not merely endure by the passage of time. They survive by the unyielding friction between power and principle. As we mark the 150 years anniversary of the Supreme Court of Ghana, a formidable milestone reflecting a history stretching far beyond our current republic, we bear witness to an apex institution that has stood as the ultimate 150 years of our collective destiny. The theme, the Supreme Court in the life of the 1992 Constitution of Ghana, taking stock and looking forward, is not a passive retrospective. It is a profound audit of our national conscience. For a century and a half, through the shifting sands of political transitions and constitutional upheavals, this court has remained the ultimate anchor of the rule of law. It is a living proof that a nation is governed not by the transient whims of men, but by the permanent majesty of law. Here within the Greater Accra region, the beating heart of the Republic of Ghana, we do not merely host the seat of justice, we shelter and very conscious of Ghana. The Greater Accra region wears this mantle with immense pride, serving as the administrative, political, constitutional capital where the scales of justice are perpetually balanced for every citizen. To honor this legacy is to protect its future. We pledge our continual resolve to foster an enabling environment where the judiciary can dispense equity without fear or favor, deepening public trust in our democratic architecture. On behalf of the people of Greater Accra Region, I salute my Lord, the Chief Justice, the justices past and present, and every guardian of the Temple of Justice. May the next chapter of this distinguished institution be written in a bolder strokes of judicial courage, institutional innovation, and unyielding fidelity to the Constitution of the Republic of Ghana. A constitution without courageous court is merely punishment. A court without fidelity is merely power. Let us endure and both remain unbreakable. On this note, I want to wish you all a happy 150 years of the Supreme Court of Justice. Hip, 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 hip. Hip, 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 hip. Hip, 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 hip. Hooray! Thank you for your audience.
Thank you, Honorable Minister. Thank you for bringing the whole room alive. I'd like to acknowledge also the chairperson of the Electoral Commission of Ghana. This is Jean Mensah. Thank you for being here. Please, once I mention you, if you can give us a little wave, we'll be very happy about that. Thank you very much. Also, I acknowledge Justice Kwabna Esuma Nedu, Chairman of the National Labour Commission. Also, Air Commodore Samuel Tete Chawe, representing the Chief of Defence Staff. There's someone I have to acknowledge now, and I just realized the coincidence of that acknowledgement. Please, let's acknowledge Mrs. Patience Bafuboni, Esquire, Director General of the Ghana Prison Service. I also acknowledge Samuel Okujeto, past President of the Ghana Bar Association. Mr. Kweku Ansah-Sari, former Director of the Ghana School of Law. Yahweh Champon Boafo, immediate past President of the Ghana Bar Association. Thank you all very much for making time to be here. We'll continue to do the acknowledgements in batches. At this time, ladies and gentlemen, the man who has the honor of presiding over this, the most enduring institution of our democratic journey, the Supreme Court of Ghana, will give us his remarks. Please make welcome His Lordship Justice Paul Bafuboni.
Please sit. The distinguished chairperson, His Lordship, Justice Retired Jones Victor Mawulom Duche, the Right Honorable Speaker of Parliament, Alban Sumana Kingsford Bagbin. I hope the irony is not lost on you that the first three names of the speaker, the initials are ASK. So if you want to know anything about Parliament, ask Bagbin. If you want to know anything about speakership, ask Bagbin. That is why we are here today, to ask him what he knows about, what he can tell us about the Supreme Court over the years. The Honorable Attorney General and Minister of Justice or his representative, my Lord Justices of the Supreme Court, active and retired, the Judicial Secretary, Mr. Ahmed Musa, my Lord and Lady Justices of the Court of Appeal in the High Court, active and retired, the Solicitor General, Mrs. Helen Akpene Awoziu, the President of the Ghana Bar Association, Mrs. Ifuagati, the President and Executive of the Law Society of Ghana, the Chairman and members of the Supreme Court at 150 Planning Committee, the Director General of Legal Education and Director of the Ghana School of Law, Professor Raymond Atuguba, distinguished members of the bench and the bar, the President of the Association of Magistrates and Judges of Ghana, the President and members of JUSAG. I was reminded that I have to acknowledge the directors and staff of the Judicial Service for their immense contribution to this celebration. Members of academia, students of law, distinguished invited guests, members of the media, ladies and gentlemen. Only a week ago, at Menchia Palace, I observed that some places call us to remember, while others invite us to reflect. Today, standing here at the Ghana School of Law, we find ourselves in a place that demands something even more profound. It asks us to think. This institution has shaped generations of lawyers, judges, and legal scholars who have gone on to serve our republic with distinction. Many of the ideas that now guide our courts were first debated in lecture rooms like these. Many of the judgments that form part of our constitutional history were conceived long before they were written in classrooms, libraries, and conversations that challenged accepted wisdom and broadened our understanding of the law. It is therefore entirely fitting that as part of the 150th anniversary celebration of the Supreme Court of Ghana, we pause at this historic seat of legal learning to reflect on one of the most defining relationships in our constitutional life, the relationship between the Supreme Court and the 1992 Constitution. Indeed, one could hardly imagine a more appropriate venue or a more distinguished audience for such a conversation. The Right Honorable Speaker, a constitution is more than a legal document. It is the highest expression of the people's aspirations for how they wish to govern themselves. It embodies our shared commitment to liberty under law, accountable governance, respect for human dignity, and the peaceful resolution of differences. Yet, a constitution does not interpret itself. Its words take on life and meaning through the institutions entrusted with giving them effect. And for more than 3 decades, under the Fourth Republic, our Supreme Court has carried this solemn responsibility. Through its decisions, it has clarified constitutional boundaries, protected fundamental rights, resolved institutional disputes, and at moments of profound national consequences, helped guide our democracy safely through uncertainty. Reasonable people may differ on particular judgments, as they should in any healthy constitutional democracy. But few can dispute that the court has remained central to the development and sustenance of our constitutional order. That is why today's lecture is so important. The theme before us invites us not merely to celebrate, but to reflect, not simply to admire our constitutional journey, but examine it with honesty, intellectual humility, and a genuine willingness to learn. We are called upon to take stock, not for the sake of criticism, not for the comfort of nostalgia, but so that we may understand more clearly what we have done well, where we have fallen short, and what the next chapter of our constitutional story should look like. For constitutions, like the institutions they create, are never finished products. They endure only when they have the courage to grow with the society they serve, while remaining faithful to the enduring values upon which they were founded. The same is true of the judiciary. Our legitimacy rests not only on our history, but on our continuing ability to dispense justice fairly, inspire public confidence, and remain worthy of the trust reposed in us by the people of Ghana. It is therefore most fitting that today's keynote lecture will be delivered by the Right Honorable Speaker of Parliament, the Right Honorable Alban Sumana Kingsford Bagbin. The choice of a lecturer could hardly be more appropriate. Before assuming the high office of Speaker, he walked the corridors of the courts, including this Supreme Court, as a distinguished legal practitioner. He then embarked on a distinguished parliamentary career spanning several decades, and earning the title the Mugabe of Parliament, becoming one of the longest-serving members of Parliament in history of the Republic, Fourth Republic. During that time, he served in a number of leadership capacities, including as Minister, Minority Leader, and Minister for Health, before assuming his current office as the Speaker of Parliament. Few public servants have witnessed our constitutional journey from so many vantage points: the courtroom, the parliamentary chamber, and beyond. He has seen the Constitution not only as a student of the law, but as one entrusted with making it, shaping it, and ensuring its practice impact on the lives of our people. His experience spans the three vital pillars of every constitutional democracy: the making of laws, their interpretation, and their effect on the citizens' lives. When we ask how the Supreme Court has shaped the life of the 1992 Constitution and how the Constitution in turn has shaped our national life, we are asking questions that the Right Honorable Speaker has not merely studied, but has lived them. I therefore look forward, as I know you all do, to his reflections on this important subject. Distinguished ladies and gentlemen, the Supreme Court at 150 is not merely looking backwards. It is looking ahead. Every anniversary worthy of the name must become an occasion for renewal. We honor those who came before us by ensuring that those who come after us inherit institutions stronger than the ones we received. That is our continuing duty. Ladies and gentlemen, it is now my singular honor to warmly welcome you all to this anniversary lecture. I remain profoundly hopeful that our discussions today will deepen our understanding of our Constitution, enrich our appreciation of the Supreme Court's place within it, and inspire us all to continue strengthening the rule of law in our beloved republic. I wish you all very fruitful deliberations, and I thank you for your attention.
Thank you. Thank you very much. Thank you very much. Thank you very much. Please, a round of applause once again. And as we know, he's a man of very few words. I'm talking about the Honorable Chief Justice quiet, calm, and fair, and he delivered. Thank you, Your Lordship. We want to acknowledge a few more people before our keynote speaker is brought on to deliver his address. But what I can assure you is that for a man who has had 33 years in Parliament, that arm of government, he would often speak a lived experience. I moderated an international conference only last week, and he was a keynote speaker. He left all of us in deep thoughts about financialization of our politics. So I can assure you, you can expect very great things to think about. We want to acknowledge Makani Chandler and the Supreme Court interns from the Pepperdine University, California. Thank you for being here. We also want to acknowledge the head of another very important constitutional body, that is the Commission on Human Rights and Administrative Justice, Dr. Joseph Whittal. I saw him here. Thank you very much. Oh, actually sitting right by Madame Jean Mensah. Thank you very much for being here. We acknowledge Justice Nia Shikote, retired Justice of the Supreme Court. Thank you, my Lord. I also saw Mr. Frank Beecham, former president of the bar. Thank you for being here. And as I said earlier, we'll be doing the acknowledgements in batches. I have a very tall list. We'll try as much as we can. Of course, right here on this campus, the landlord, okay, I need to be careful about saying Professor Raymond Akumburo Atugba is the landlord. All right, so thank you for the Director of Legal Education and the Ghana School of Law, Professor Raymond Akumburo Atugba. Thank you for also being here. We will now welcome Mrs. Helen Akpene Awu-Ziu, Solicitor General, to bring forth our keynote speaker. Please, a round of applause for her.
Yes, I am. I'm doing precisely that. Okay.
The Solicitor General will welcome the Speaker of Parliament shortly, but I want to take advantage of the little time in between to acknowledge a few people who are here on my lists. State services and emergency agencies, representatives of the Ghana National Fire Service, led by DCFO James Ohini Bayao Kwateng, Legal and Prosecutions, E&R Laws, Konedu Bonti, National Service Personnel, and NCC Head Office, led by Asani Mohammed. We are acknowledging all of you because you're important to this program as well. So thank you one more time. I believe that as we wait for the speaker, we can, in the meantime, have another round of the Ghana Dance Ensemble. In the meantime, the Judicial Service is grateful to the Ghana Broadcasting Corporation, Director General, Professor Amin Al-Hassan, for offering the GBC's platform for free. I think we should clap to that. So we are live on GBC News Channel, and we are also live on the Judicial Services YouTube channel at Judiciary Ghana, Thank you for that. We also acknowledge the presence of Mrs. Joy Osei Owusu-Labi Na Sewa, the acting National First Vice Chairperson for Finance of the Convention People's Party. Thank you for being here. All right, I see you right there. All right.
Chairperson of this lecture, the Right Honorable Speaker of Parliament of the Republic of Ghana, His Lordship the Chief Justice of the Republic of Ghana, His Lords Temporal and Spiritual, members of the Judicial Council, my Lords and Ladyships of the Supreme Court, retired Justices of the Supreme Court, my Lords and Ladyships of the Superior Courts of Judicature, the Judicial Secretary, distinguished members of the lower bench, honorable members of Parliament, Honorable Attorney General and Minister for Justice or his representative, the Greater Accra Regional Minister, and honorable ministers herein present, the President of the Ghana Bar Association, and the President of the Greater Accra Regional Bar, members of the General Legal Council and the Ghana Law School, distinguished members of the Bar, distinguished members of academia, as well as distinguished heads of public service institutions, distinguished invited guests, ladies and gentlemen, all protocols duly observed. Good morning. It is my singular honor and privilege to introduce our distinguished keynote speaker for today's anniversary lecture marking the 150th anniversary of the Supreme Court of Ghana. Right Honorable Alban Sumana Kingsford Bagbin, Speaker of the 9th Parliament of the 4th Republic of Ghana, is an accomplished lawyer, statesman, parliamentarian, and transformational leader whose distinguished career in public service spans more than 4 decades. Called to the bar in 1982, he has distinguished himself in legal practice, public administration, and parliamentary leadership. For 28 years, he served the people of Ghana as a member of parliament, during which he occupied virtually every major leadership position in the House, including
minority leader, majority leader, leader of government business, and second deputy speaker, before ascending to the high office of Speaker of Parliament. He's the first person ever in Ghana's history to have risen through all these ranks to become a Speaker of Parliament. Well done. Since assuming office as Speaker, Right Honorable Gbagban has championed significant institutional reforms aimed at strengthening Parliament's openness, accountability, and responsiveness. His tenure has witnessed the revision of Parliament's standing orders, the introduction of a code of conduct for members of Parliament, and the establishment of the National Integrity Award Scheme. Beyond Ghana's borders, he has distinguished himself as a leader in parliamentary diplomacy, having served as president of the Commonwealth Parliamentary Association and currently serving as president of the Conference of Speakers and Presidents of African Legislatures, chairperson of the African Geopolitical Group of Interparliamentary Union, and the president of the African Parliamentary Network Against Corruption. A recipient of numerous national and international honors, including an honorary degree of law's degree, and the Millennium Excellence Award. Right Honorable Gbagban is widely admired for his steadfast commitment to democracy, integrity, social inclusion, and nation building. Throughout his illustrious career, he has remained steadfast advocate for constitutionalism, good governance, and the rule of law, and the strengthening of democratic institutions. His wealth of experience, which has been said this morning by almost all speakers, in the legislation, public policy, and constitutional governance has earned him immense respect both within Ghana and internationally. As we commemorate 150 years of the Supreme Court of Ghana and reflect on the theme, the Supreme Court in the life of the 1992 Constitution, taking stock and looking forward, there could scarcely be a more fitting speaker to guide our reflection than one who has played an instrumental role in shaping Ghana's democratic and constitutional journey. Distinguished ladies and gentlemen, we are indeed honored that he has accepted our invitation despite his demanding schedule. Please join me in extending a warm, hearty welcome to our distinguished keynote speaker, the Right Honorable Agban Sumana Kingsford Gbagban, Speaker of the 9th Parliament of the 4th Republic of Ghana.
Please, kindly resume your seats.
Right Honorable Speaker, the floor is yours. Thank you.
His Lordship, Justice Jones Maulom Doche, the Venerable Chairman for this lecture. My Lord, the Chief Justice of Ghana, may I, with all humility, crave your indulgence to adopt the protocol already established by earlier speakers. Let me greet all of you. I don't know whether it's morning or afternoon now. It's still morning. I don't intend to take you for more than 2 hours. Is that too short a time? Well, I recognize the presence of some people. I know in spite of my height, there are a lot of people here that are taller than me. So I'll promise you on my honor, I will not talk about the poverty of the judiciary. You know, that is very visible in my attire. The material they gave me could only sew one piece. Not even 2 pieces, much more 3-piece suit. I won't talk about that poverty. I'll be talking about the wealth of the Supreme Court. I say, I promise on my honor. As a student of law and governance, I deem it a great honor and privilege to be invited to deliver a lecture to mark the celebration of the 150th anniversary of the Supreme Court of Ghana. I'm deeply grateful to His Lordship, the Chief Justice, who is a very, very close friend and one of my colleagues, the Aluta graduates. I'm grateful to the Judicial Service and the Planning Committee for the invitation to deliver this 3rd anniversary lecture as part of the historic celebration of the Supreme Court of Ghana. I'm even more grateful to the chairman of the occasion. I was just recalling how in my practice, I used to have a few cases in the High Court in Ho, and he was one of my seniors I looked up to. And around the year 2000, I had to even refer some of my constituents who were being attended to by the law there to him to handle the cases for me. I'm extremely grateful to see you still looking so young. I received the invitation not merely as a personal honor, nor solely as a courtesy extended to the Parliament of Ghana, but as a recognition of the enduring constitutional relationship between two co-equal institutions that stand at the heart of our democratic republic. Parliament and the judiciary exercise distinct constitutional mandates, yet they are united by a common constitutional purpose, and that is to uphold the Constitution, preserve the rule of law, and safeguard the democratic aspirations of the people of Ghana. Today's celebration marks far more than the passage of 150 years. It commemorates the remarkable journey of one of Ghana's oldest and most enduring public institutions, whose evolution has been inseparably intertwined with the constitutional, political, and legal development of our nation. Few public institutions in Ghana have endured for 150 years. Fewer still have remained relevant through successive constitutional dispensations, changing systems of government, and profound political transformation. Established in 1876 by the enactment of the Supreme Court Ordinance during the colonial era, the Supreme Court has witnessed the transition from colonial administration to independence, from parliamentary government to Republican governance, through periods of constitutional interruption and military rule, and ultimately to the restoration and consolidation of constitutional democracy under the Constitution 1992. Its institutional memory spans almost every defining chapter of Ghana's constitutional history. Indeed, the history of the Supreme Court mirrors, in many respects, the constitutional history of our republic itself. Across changing constitutional orders, evolving political philosophies, and successive generations of judges, the court has remained a central institution to the administration of justice. While its jurisdiction, institutional design, and jurisprudence have necessarily evolved, its enduring responsibility has remained constant, and that is to administer justice according to law and to uphold the constitutional order of the state. For that reason, this sesquicentennial is not merely a judicial celebration. It is a national milestone. The significance of this anniversary extends well beyond the judiciary. The rule of law is not the preserve of judges alone. Constitutionalism is not the exclusive concern of lawyers. The administration of justice is not merely a judicial enterprise. These are national values upon which the peace, stability, and democratic governance of our republic depend. Every Ghanaian, and I mean it, every Ghanaian who has exercised the right to vote in peaceful elections, every citizen who has sought protection against unlawful governmental action, every institution that has discharged its constitutional mandate within the framework of law, and every generation that has witnessed the peaceful transfer of political power has, in one way or another, benefited from the work of the judiciary and ultimately from the constitutional leadership of the Supreme Court. The court has therefore occupied a place that extends beyond the courtroom. It has become one of the principal institutions through which constitutional democracy has been nurtured, constitutional disputes peacefully resolved, and public confidence in the rule of law sustained. Its contribution to national development cannot be measured solely by the judgments it has delivered. It must always be measured by the constitutional stability it has helped to secure and the confidence it has inspired in democratic governance. This lecture, therefore, matters to all of us. Anniversaries of this significance invite more than celebration. They invite honest national reflection. They require us to look back with gratitude, assess the present with intellectual honesty and institutional humility, and look to the future with confidence and renewed purpose. The theme assigned for this lecture, the Supreme Court in the life of the 1992 Constitution, taking stock and looking forward, captures that responsibility with admirable precision. It invites us to consider the Supreme Court established by Article 126, Clause 1 of the Constitution of the Republic of Ghana, not merely as an institution of distinguished history, but as a unique living constitutional actor whose decisions, jurisprudence, and institutional leadership have profoundly influenced the operation of the Fourth Republic over the past 33 years. Equally, it challenges us to reflect on the future. As Ghana's democracy continues to mature, the constitutional questions confronting the court will become increasingly complex. Advances in technology, evolving notions of human rights, changing models of governance, economic transformation, and rising public expectations will continue to test the resilience of our constitutional institutions. The question before us, therefore, is not simply how the Supreme Court has served the Constitution over the past 33 years. It is how it must continue to serve the Republic and the people in the decades yet to come. So what is the central thesis of this lecture? The central thesis of my lecture is straightforward. No institution has exercised a greater influence on the practical operation of the Constitution 1992 than the Supreme Court. Through its interpretation and enforcement of constitutional governance, the deployment of constitutional doctrine, the protection of fundamental rights and freedoms, the resolution of disputes among the organs of state, and the articulation of constitutional principles, the court has profoundly shaped the constitutional character of the Fourth Republic. Its jurisprudence has influenced not only the development of the law, but also the conduct of public institutions, the expectations of citizens, and the evolution of Ghana's constitutional culture. Yet, constitutional maturity demands more than celebration. No doubt, a lot has been achieved. Yes, a lot has been achieved. But it's equally a truism that a lot is yet to be achieved. This requires honest reflection, and honest reflection I commit to do in this lecture. The true strength of a constitutional democracy lies not in the unquestioned authority of any single institution, but in the fidelity of all constitutional actors to the Constitution itself. The Constitution, not Parliament, not the executive, and not the judiciary, remains supreme. The continuing challenge for every arm of government is to exercise its constitutional authority in a manner that strengthens rather than disturbs the constitutional order established by the framers of the Constitution. It is against that standard that we must take stock of the Supreme Court's contribution to our constitutional democracy and consider the responsibilities that lie ahead. So what is the roadmap of this lecture? Accordingly, this lecture proceeds in 4 substantive parts. First, I shall examine the place of the Supreme Court within the constitutional architecture of the Fourth Republic and the pivotal role assigned to it under the Constitution. Second, I shall take stock of the Court's contribution to Ghana's constitutional democracy by examining its jurisprudence, its protection of constitutional supremacy and the fundamental rights, its role in preserving democratic stability, its constitutional dialogue with Parliament and the other arms of government, and the institutional challenges that remain. Third, I shall offer some reflections on the future of the constitutional adjudication in Ghana, including the imperative need to preserve the rule of law, maintain coherence in constitutional interpretation, uphold the delicate equilibrium among the arms of government, and ensure that the judiciary continues to command the confidence and trust of Ghanaians and the world. Finally, I shall conclude with some reflections on the shared constitutional responsibility of all institutions of state to preserve, protect, and defend the Constitution for present and future generations. Ladies and gentlemen, it is with these objectives in mind that I now turn to the first substantive question posed by today's team. What place has the Supreme Court occupied in the life of the Constitution, 1992? And how has it helped to shape the constitutional democracy that Ghanaians have come to cherish? Ladies and gentlemen, the adoption, enactment, and giving to ourselves this Constitution marked far more than the inauguration of another constitutional order. It represented the collective determination of Ghanaian people to break decisively with a history of constitutional instability and to establish a democratic state founded upon constitutional supremacy, the rule of law, respect for fundamental human rights, accountable governance, and the separation of powers. Unlike previous constitutional experiments that were interrupted by unconstitutional changes of government, this Constitution and the Fourth Republic has endured for more than 3 decades. In fact, that explains the length of my stay in Parliament. It has become Ghana's longest uninterrupted period of constitutional governance since independence. Please, I'm the longest serving member of Parliament. I am not the oldest member of Parliament. I hear many of you giving me an age which I don't deserve. Please. It's only in Parliament I'm the longest serving. Let me repeat. It has become Ghana's longest uninterrupted period of constitutional governance since independence. This rare achievement is lost on many in Ghana. That remarkable achievement cannot be attributed to any single institution or individual, but to a generation of national leaders. It is the product of great sacrifice of many Ghanaians and the continuing fidelity of the Republic's constitutional institutions to the constitutional compact embodied in the Constitution. Among these institutions, the Supreme Court occupies a position of singular constitutional visibility and importance. The framers of the Constitution deliberately entrusted the Supreme Court with responsibilities that extend beyond those traditionally associated with the judicial function. They envisaged a court that would not merely determine disputes between litigants, but would serve as the principal guardian of the constitutional order itself. The Supreme Court was therefore designed to be the only court we call apex court of the judicial hierarchy, and as the principal constitutional custodian of the Republic. This ended the parallel tracks of the public tribunal and the Supreme Court in the exercise of criminal jurisdiction. As the custodian and guardian of constitutional supremacy, the Supreme Court, as a central organizing principle of the Constitution, is the supremacy of the Constitution itself. And this has been articulated a number of times. And I'll repeat it here, not just for emphasis, but for effect. Article 1 declares that the sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government are to be exercised in the manner and within the limits laid down in the Constitution. Article 1 further proclaims that the Constitution is the supreme law of Ghana, and that any other law found to be inconsistent with it shall, to the extent of the inconsistency, be void. Constitutional supremacy, however, cannot exist merely as a declaration. It requires an ultimate institution capable of giving practical effect to that principle. That responsibility rests and I forcefully submit rightly with the Supreme Court and not any other constitutional or legal creation. Under Article 2, the Supreme Court is empowered to determine whether any enactment or conduct is inconsistent with the Constitution. Under Article 130, it possesses exclusive original jurisdiction in all matters relating to the enforcement or interpretation of the Constitution. Under Article 131, the Supreme Court exercises final appellate jurisdiction over all superior courts. Taken together, these provisions confer upon the court a constitutional responsibility unlike that entrusted to any other institution of state. Its duty is not merely to interpret the Constitution. Its duty is to ensure that the Constitution is obeyed and given effect. Every constitutional democracy ultimately depends upon an institution capable of ensuring that constitutional limits remain meaningful and that every exercise of public power remains subject to constitutional scrutiny. In Ghana, that institution, according to the Constitution, is the Supreme Court, a product of a checkered history, a unique but complex court. It is a constitutional court, a court of first instance, a supervisor of other courts, a final appellate court, a review court, and as an election court. But all these several types of jurisdiction does not make the Supreme Court supreme over all constitutional institutions in all matters of the rule of law. I'm sure I'm clear. The Supreme Court clearly is the final constitutional arbiter. The significance of the Supreme Court lies not only in the jurisdiction conferred upon it by the Constitution, but also in the character of the questions it is called upon to determine. Constitutional disputes rarely concern private rights alone. They frequently involve the distribution of public power, the interpretation of, and the application by constitutional institutions, and the mediation and reconciliation of competing constitutional values. Questions concerning the powers of Parliament, the authority of the executive, the protection of fundamental rights, the conduct of elections, the validity of legislation, and the interpretation of constitutional procedures ultimately find their way before the Supreme Court. In resolving such questions, the court performs a function that extends beyond adjudication. It gives practical meaning to the Constitution. It defines constitutional boundaries. It clarifies institutional responsibilities. It has the opportunity to contribute to the development and maintenance of a system of good governance. It ensures that the constitutional power is exercised only, and I mean only, within constitutional limits. In this sense, every constitutional judgment contributes to the continuing life of the Constitution itself. The court does not merely interpret constitutional provisions, it shapes the manner in which those provisions operate within the daily life of the Republic. The influence, therefore, of the Supreme Court extends far well beyond the courtroom. Its decisions shape what constitutional scholars often describe as a nation's constitutional culture. A constitution becomes meaningful not merely because it exists as a legal document, but because citizens, governments, and public institutions develop confidence that constitutional disputes will be resolved peacefully and according to law. One of the most remarkable achievements of the Fourth Republic has been the gradual emergence of such a constitutional culture. Today, constitutional controversies that might once have generated political confrontation are increasingly submitted to judicial determination. Governments comply with constitutional judgments. Parliament adjusts its procedures in response to constitutional interpretation. And you recall the decision of the court in the case of the deputy speakers, whether the deputy speakers have a right to vote whilst presiding over parliamentary proceedings. That decision guided us to revise our standing orders and update them to comply with the law. And I want to take this opportunity to thank the Supreme Court for that guidance. We definitely complied with the law. Governments comply with constitutional judgments. As I said, Parliament adjusts its procedures in response to constitutional interpretation. Public institutions increasingly seek constitutional guidance before acting. Citizens invoke constitutional rights with growing confidence. These developments reflect more than legal progress. They demonstrate the gradual entrenchment of constitutionalism within Ghanaian public life. The Supreme Court has played a central role in nurturing the constitutional culture by providing authoritative constitutional interpretation and peaceful resolution of institutional disputes. It has strengthened public confidence that constitutional disagreements should be resolved not through political confrontation or extra-constitutional means, but through the institutions established by the Constitution itself. Perhaps no greater contribution can be made to a constitutional democracy than what the Supreme Court has done. Ladies and gentlemen, every constitution is intended to endure. Yet, no constitution can anticipate every challenge that future generations will encounter. The framers of the Constitution, 1992, understood this reality. They established enduring constitutional principles while entrusting future generations, and particularly the judiciary, with the responsibility of ensuring that these principles remain capable of guiding an evolving democratic society. In that sense, the Supreme Court performs a role that may properly be described as constitutional stewardship. It must remain faithful to the text of the Constitution while ensuring that its provisions continue to serve the broader constitutional values for which the Constitution was adopted. It must preserve constitutional continuity without resisting legitimate constitutional evolution. It must safeguard constitutional certainty while ensuring that the law remains responsive to changing circumstances. This is not easy responsibility. It demands legal scholarship, institutional wisdom, constitutional restraint, cool heads, and above all, an unwavering fidelity to the Constitution. We are lucky in Ghana. We have the men and women of intellect and wisdom to do this. Many of you don't know that our judges are rare species, and they value more than Ghana, and they are sought for everywhere in the world. So please, let's guard them jealously. And let me say this. For the Supreme Court's authority ultimately derives not from the power to pronounce the law, but from the confidence of the Ghanaian people that its judgments faithfully reflect the Constitution and strengthen the democratic order established in their name. It should never be lost to any person that the power of the Supreme Court to interpret and to enforce the provisions of the Constitution emanate from the people. It is a delegated power. It is again this constitutional mandate that the work of the Supreme Court over the past 3 decades must be assessed. Accordingly, having considered the constitutional role assigned to the Supreme Court under the Constitution, I now turn to the central evaluative task posed by today's theme to take stock of the Court's contribution to Ghana's constitutional democracy and to acknowledge its achievements, to reflect upon the challenges that remain, and to consider the lessons that may guide its future. Having reflected upon the constitutional place assigned to the Supreme Court under the Constitution, it is now appropriate to undertake the exercise contemplated, as I said, by today's theme, to take stock. To take stock is neither to celebrate uncritically nor to criticize unfairly. It is to assess an institution honestly, recognizing its achievements, acknowledging its challenges, and considering how it may continue to strengthen the constitutional order entrusted to its care. Such reflection is particularly appropriate for an institution that has stood at the apex of Ghana's judicial system for many of the 150 years and has occupied a central place in the constitutional life of the Fourth Republic for more than the 3 decades. Please, it's not since 1876, nor all the years that the Supreme Court has always been the final and apex court of the land. That should be noted. But the true measure of the Supreme Court's contribution cannot be found simply in the number of constitutional cases it has determined or the volume of reported decisions. Rather, it lies in the extent to which its jurisprudence has strengthened constitutional government, reinforced the rule of law, protected individual liberty, preserved democratic stability, and inspired public confidence in the Constitution itself. Measured against those constitutional benchmarks, the Supreme Court has made an enduring contribution to the success of the Fourth Republic. And I think they deserve an applause. I'm also going to take note of the Supreme Court as the guardian of constitutional supremacy. Perhaps the court's most significant contribution has been its steadfast affirmation that the Constitution remains the supreme law of the Republic. Constitutional supremacy is the cornerstone upon which every democratic institution rests. Without an independent institution prepared to enforce constitutional limitations, the supremacy of the Constitution will remain little more than an aspirational declaration. Through its original jurisdiction under Articles 2 and Article 30, the Supreme Court has repeatedly demonstrated that constitutional authority must prevail over political convenience. I now pause to take a sip. Being a rural boy, I'm drinking from the bottle. Landmark decisions, such as New Patriotic Party versus the Attorney General. I'm talking about the 31st December case. Justice Abdullahi versus the Attorney General, and Professor Appiagyei Atua versus Attorney General have become enduring pillars of Ghana's constitutional jurisprudence. Let me single out the case of the New Patriotic Party versus Attorney General. Many of you are very young, so sometimes you cannot estimate the value of some of the decisions of the court. Just consider Ghana in the early 1990s. The nation was emerging from years of military rule into a new and fragile constitutional democracy. Yet, the state continued to spend public funds celebrating the December 31st military coup. In MPP versus the Attorney General, the Supreme Court drew a constitutional line. It held that a democratic state could not use public resources to commemorate the violent overthrow of a constitutional government. In doing so, the court affirmed that under the 1992 Constitution, the ballot, not the bullet, commands constitutional legitimacy. People have forgotten that the 24 February 1966 coup is not celebrated. The 13th January 1972 coup is not celebrated. Why should the 31st December 1981 coup be celebrated? June 4th can be celebrated because it brought to an end an unconstitutional rule. You can celebrate the other days, not with state funds, with your private funds. The Supreme Court has no problem with that. but with the people's money? The answer, according to the Supreme Court, is no, and never again. I hope this has elucidated to the politicians why the Supreme Court was right in that decision. By insisting that constitutional power must always remain subject to constitutional restraints, the court has transformed constitutional supremacy from a textual declaration into an operational principle of democratic governance. Let's look at the delicate constitutional equilibrium which has been put into the hands of the Supreme Court as the custodian. The Supreme Court has also performed an indispensable role in preserving the constitutional order established by the framers of the Constitution. The genius of the Constitution lies not merely in its separation of powers, even that people are debating over it, but in its delicate balancing of those powers. Parliament legislates. The final authority to make law rests with Parliament and no other institution. The executive president, who is defined in the Constitution as the government, governs. And that is why cabinet is advisory. So when I hear people talk about cabinet approval, it's a hangover. Cabinet has no power to approve. They only have the power to advise. Are we together? I haven't started yet. We must always remember this. Each institution derives its authority from the same constitutional source. And so the judiciary is the one that is called upon to interpret and to enforce the Constitution. So even though each arm is independent in the performance of its constitutional mandate, none is supreme over the Constitution. Throughout the life of the Fourth Republic, the Supreme Court has repeatedly been invited to define the constitutional boundaries separating these institutions. Its decisions in J.H. Mensah versus the Attorney General, Professor Stephen Kweku Asare versus the Attorney General, Ezueme Manan versus the Attorney General, and other important constitutional cases have clarified institutional responsibilities and strengthened constitutional accountability. In doing so, the court has helped preserve the constitutional architecture upon which the democratic governance is anchored in Ghana. I recall vividly my role in Parliament, which led to the J.H. Mensah versus Attorney General's case. At that time, I was the chairman of the Committee on Constitutional, Legal, and Parliamentary Affairs. And I led my team to hold a view, forcefully, that once the president's nominees had earlier on, in the first Parliament of the Fourth Republic, been granted approval by Parliament. There was no need for them to get a second approval from Parliament. My senior, in fact, my father, J.H. Mensah, led the other team. They disagreed with us, and they came to the Supreme Court. It was a very big test for the Supreme Court. Yet, with intellect and wisdom, they were able to hold and harden the balance and delivered a judgment which is well respected up to date. And these judgments have helped to preserve the constitutional architecture upon which our democratic governance is anchored as of today. Now, looking at the Supreme Court as the protector of fundamental rights and freedoms, let me say this. It is equally significant, very significant, that the court's contribution to the protection of the fundamental rights and freedoms guaranteed under Chapter 5 of the Constitution have also not been found wanting. Constitutions ultimately exist for people. Their legitimacy depends not only upon the organization of public power, but also upon the protection of human dignity. The Supreme Court has, over the years, progressively developed a rights-centered constitutional jurisprudence. Through decisions such as New Patriotic Party versus the Inspector General of Police, Ahoma Okanse versus the Electoral Commission, Center for Human Rights and Civil Liberties versus Attorney General, Awuni versus West African Examination Council, and Martin Pebu. The court has reinforced the principle that constitutional rights are not merely declaratory ideals, but enforceable legal guarantees. In doing so, it has strengthened public confidence that liberty remains protected by an independent judiciary. How has all this anchored the stability of our democracy? Perhaps nowhere has the Supreme Court's constitutional significance been more evident than during periods of political contestation. Every constitutional democracy is ultimately tested, not during periods of consensus, but during periods of disagreement. Ghana has experienced such moments, yet one of the defining characteristics of the Fourth Republic has been the willingness of political actors to submit even the most contentious constitutional disputes to judicial determination. I will cite just one: the 2012 presidential election petition. That petition remains perhaps the clearest demonstration of this constitutional maturity. It tested the Supreme Court. Regardless of different political opinions regarding the outcome, the proceedings demonstrated that constitutional controversies of the highest political significance could be resolved peacefully within the framework of the law. That remains one of the great constitutional achievements of the Fourth Republic. We owe the Supreme Court a debt of gratitude for saving our constitutional democracy. Let me now touch on the dialogue between Parliament and the judiciary. co-equal institutions. Perhaps no constitutional relationship better illustrates the maturation of Ghana's constitutional democracy than the evolving relationship between Parliament and the Supreme Court. The Fourth Republic has witnessed an increasing number of constitutional disputes involving parliamentary proceedings, legislative enactments, and the exercise of parliamentary authority. This development should not be regarded as evidence of institutional conflict. Rather, it reflects the natural consequence of a constitutional order founded upon constitutional supremacy and judicial review. Through its decisions, the Supreme Court has clarified the constitutional limits of legislative authority, interpreted parliamentary procedures, examined the scope of parliamentary privilege, and reinforced the principle that every constitutional institution, including Parliament itself, remains subject to the Constitution. Sometimes my good self have problems with some of their decisions. But who am I? And let me say this. These decisions have not always escaped criticism within Parliament or the wider constitutional community. Nor should one expect, I should say, them to. Definitely, they are subject to criticisms, and sometimes some wild words are used against the court. Constitutional adjudication frequently requires courts to determine difficult questions upon which reasonable constitutional actors may legitimately disagree. Such disagreement is neither unusual nor unhealthy. Indeed, it is often the hallmark of a vibrant constitutional democracy. The true constitutional maturity is not the absence of institutional disagreement, but the ability of constitutional institutions to resolve these disagreements through lawful due processes, mutual respect, and fidelity to the Constitution. Parliament and the judiciary derive their legitimacy from different constitutional sources. In fact, the Chief Justice referred to it. Parliament speaks from the democratic mandate of the electorate. The judiciary speaks with the authority of the Constitution. Neither source of legitimacy diminishes the other. Rather, both are indispensable to the preservation of constitutional democracy, since both emanate from the same source, the people of Ghana. Accordingly, judicial review should continue to be exercised with due regard for Parliament's constitutional role as a representative institution of the supreme people, just as Parliament must continue to respect the judiciary's exclusive responsibility to interpret and enforce the Constitution. Both are called upon to uphold, preserve, protect, and defend the Constitution. And you can read the oaths we swear. Institutional community is not constitutional difference. It is the disciplined recognition that constitutional government flourishes when each arm of government faithfully performs its own constitutional responsibilities while respecting the constitutional competence of others. Now let me take stock And this talk deals with institutional renewal and the stewardship of the Supreme Court. Taking stock always requires intellectual honesty. No constitutional institution, however distinguished, can rely upon its history alone. Every generation renews public confidence in constitutional institutions through its own conduct. The Supreme Court is no exception. The increasing complexity of constitutional litigation, the growing demand for timely justice, the need for greater accessibility, the importance of coherent constitutional jurisprudence, and the expectations of a technologically sophisticated society all present new institutional challenges. These are not uniquely Ghanaian concerns. They confront constitutional courts throughout the democratic world. The distinguishing characteristic of great constitutional courts is not that they avoid such challenges, but they confront them with openness, wisdom, courage, and a continued commitment to institutional renewal. As we take stock of the Supreme Court's contribution to the life of the Constitution, particularly the 1992 Constitution, one conclusion emerges with unmistakable clarity. And it's this: the Supreme Court has been one of the principal architects of Ghana's constitutional democracy. Through its jurisprudence, it has strengthened constitutional supremacy, protected fundamental rights, preserved democratic stability, clarified the relationship among the organs of state, and reinforced public confidence in constitutional government. In fact, for some of these reasons, in our new standing orders, we had to establish some new committees to try to assist the court in some of the matters that erupt in the country, so that not everything is sent to the Supreme Court. It will be so much inundated. And Ghanaians are worried about the numbers at the Supreme Court. They don't want more, they want less. Yet every day, they are cap in hand, going before the Supreme Court for handouts. Please, we have established a committee on human rights in Parliament, with a department, a technical department, made up of some of the distinguished legal luminaries here to assist us. We are also appointing a commissioner on ethics and standard. He should not be below the qualification of a court of appeal judge. We're doing all this and others to make sure that at least we can provide a buffer for the Supreme Court. But let's delve our hands and our heads and our hearts for the Supreme Court. The achievements of the Supreme Court deserve recognition, but they also carry an enduring responsibility. For every generation inherits constitutional institutions from those who came before. The measure is whether those institutions are handed to the next generation stronger than they were received. It is against that responsibility that we must now consider the future. For the question before us is no longer simply what the Supreme Court has achieved. The more important question is what the Republic will require of the Supreme Court in the decades ahead. It is to that future and to the constitutional responsibilities that accompany it that are now 10. Ladies and gentlemen, every significant constitutional authority, every significant constitutional anniversary is both a celebration of achievement and an invitation to renewal. It challenges an institution not merely to reflect upon its past, but to prepare itself for the constitutional demands of the future. The Republic that the Supreme Court will preserve over the coming decades will be markedly different from the Republic that emerged in January 1993. In fact, what emerged in January 1993 was a product of extreme disagreement. I was part of it. The constitutional questions of tomorrow will increasingly arise from technological innovation, artificial intelligence. I repeat, artificial intelligence, digital governance, cyber security, data protection, biotechnology, environmental justice, climate change, regional economic integration, cross-border commerce, and rapidly evolving conceptions of individual rights and governmental responsibility. Please, the poverty of the judiciary must end. If we actually want them to perform, you can see the task ahead. My political colleagues, let's rise up to the challenge. The Supreme Court will be called upon to resolve questions that the framers of the Constitution could scarcely have anticipated. The Supreme Court exists to uphold the supremacy of the Constitution. Yet, while the issues confronting the court will inevitably change, its constitutional mission must remain constant. It exists to safeguard the rule of law. What is the ground of the rule of law? The Constitution. We say we are doing constitutional review. This is another time for us not to blink, but to make sure we set the rule of law right. Well, the Supreme Court exists to truly and faithfully administer justice impartially, without fear or favor, affection or ill will. It exists to preserve the constitutional order upon which democratic governance depends. So if you give them some constitutional order and they want to remain faithful to it, and interpret and enforce that rule of law, please, it doesn't lie in your mouth to come back to attack them. And so I'm urging all of you that this opportunity for us to have a second look at our Constitution should be taken seriously by all of us. I will not blink my eye. And I call on all of you to remain awake like election day. Let me say that those responsibilities remain timeless and sacred. The greatest tribute we can pay those who built this institution is not merely to celebrate its history, but to leave it stronger than we found it, more independent, more accessible, more transparent, and more intellectually rigorous. May the next 150 years produce a Supreme Court admired not merely because its decisions are final, but because its reasoning is principled. Its processes inspire confidence. And every Ghanaian, regardless of status or political persuasion, approaches its doors with the quiet assurance that justice will be done according to law. You heard the positions I held. I can give you accurate history because I'm a student of history too, not only of law and governance, of each political tradition. And what is happening today should not be happening unless we are not learning the lessons of the past. Please, don't blame me when I snap in presiding the House. It's because of what I have experienced, what I have gone through, what I have heard and seen in this country. And sometimes you can engage me in private. I'll disclose to you. Some are not good for the public. I don't know it all, but at least I can share these experiences and information with you. Let me now look at a little bit of the independence, impartiality, and constitutional accountability. I promise not to take you more than 2 hours. That promise I will hold. The enduring strength of the Supreme Court rests first and foremost upon its independence, impartiality, diligence, and application to duty. Independence of the Supreme Court, notwithstanding what other players may say, remains one of the greatest constitutional achievements of this Constitution. Please read the first Constitution we submitted to our colonial masters when we were about to gain independence. It wasn't what they gave us. What we submitted to them, they disagreed with us and gave us something different. But our first Prime Minister said, please, let's accept it. When we now have the authority, then we will decide what to do with it. And clearly, that was what happened. So we transited with a new constitution in 1960 to a republic. Start reading from those constitutions up to date, and you see the difference. Without an independent Supreme Court, constitutional supremacy would become vulnerable, fundamental rights insecure, and democratic governance uncertain. I pray that the Supreme Court of Ghana will continue to demonstrate the qualities that have made it a venerable and revered national arbiter. The court should persevere in upholding the rule of law. That would be its priceless contribution to Ghana's development. Independence, however, is not an end in itself. Its constitutional purpose is to enable judges to decide cases according to law, free from improper influence, external pressure, or political expediency. Political expediency belongs to the politicians, not to the judiciary. Independence must therefore always be accompanied by an equally profound fidelity to constitutional principle. Not only the court or the judiciary, but each and every one of us. The culture of constitutionalism must be cultivated by all of us. The confidence of the people is the judiciary's greatest institutional asset. That confidence cannot simply be assumed, because judicial authority is constitutionally guaranteed. Just because it's guaranteed, we cannot assume that the people are confident in whatever happens in the judiciary. It must continually be earned through integrity, through impartiality, through consistency, and through intellectual rigor of both the institution and the people serving it. Above all, it is earned through judgments that persuade by the force of constitutional reasoning and benefits to reinforce public confidence that justice has been administered according to law. But there are some dangers. I'll restrict myself to only two. Those two dangers are twin dangers. As the court looks to the future, it must remain vigilant against these two constitutional dangers. The first is constitutional overextension. The Constitution entrusts enormous authority to the Supreme Court. Jurisdictionally, the Supreme Court exercises an exceptionally broad and multifaceted jurisdiction. Many of the judges and the lawyers will tell you the uniqueness of our Constitution, and particularly what we set up as Supreme Court. I don't know where else in the world you have one like that. My studies as a student hasn't revealed any. There are pieces from all the jurisdictions we have put together and created something unique, something that is meant for Ghana. The court must resist the temptation to extend its jurisdictional powers to matters that might be considered as constitutional overextension. The authority of the court must always be exercised with constitutional discipline. Courts strengthen democracy, not by assuming responsibilities entrusted to the political branches, but by ensuring that every institution faithfully performs the responsibilities assigned to it by the Constitution. My humble submission is for the Supreme Court to deploy its powers in ways which make the law serve the purpose of society. The temptation to substitute judicial preference for constitutional command must always be resisted. I don't want to cite cases in this respect. The second danger is excessive judicial restraint. There will be moments where constitutional rights are threatened, constitutional limits disregarded, or democratic institutions placed under strain. At such moments, excessive restraint may prove as damaging to constitutional democracy as excessive intervention. In the same way, the Supreme Court should, I want to quote this, it's from one of your illustrious writers, a jurist. I quote it. In the same way, the Supreme Court should, and I quote, restrain itself from expanding its jurisdiction by interpretation to cover more and more non-strategic cases. Its case load needs to be limited so that it can be more effective and able to concentrate on the leading strategic leader issues affecting national life, unquote. I quote this with approval. The Constitution expects the Supreme Court to act neither timidly nor aggressively. It expects the Supreme Court to act constitutionally. The enduring authority of the Supreme Court would therefore lie in its ability to avoid both extremes while remaining unwavering in its fidelity to the Constitution. One other issue I want to highlight is the need for jurisprudential coherence. Closely connected to this responsibility is the continuing need for coherence in constitutional interpretation. The authority of the Supreme Court derives not merely from the finality of its judgments, but from the quality, coherence, and predictability of its constitutional reasoning. Constitutional adjudication must provide clarity where uncertainty exists, certainty where ambiguity persists, and principled guidance where public institutions seek constitutional direction. Citizens, parliaments, the executive, investors, and the wider society organize their affairs upon the reasonable expectation that constitutional principles will be interpreted consistently and applied predictably. In this regard, one of the continuing tasks before the court is the development of a coherent philosophy of constitutional interpretation. Over the years, the court's jurisprudence has, at different times, drawn upon both textualism and purposivism, or functionalism, in interpreting constitutional provisions. Neither approach is inherently objectionable. Each serves an important function in constitutional adjudication. Textualism reminds us that judges must remain faithful to the language adopted by the people in their constitution. Purposivism reminds us that constitutional provisions must always be interpreted in light of the broader values, objectives, and aspirations that the Constitution was intended to secure. The challenge, however, is not the legitimacy of either methodology. The challenge is ensuring principled consistency in determining when each approach is appropriately employed. Where constitutional interpretation appears to oscillate unpredictably between textualism and purposivism without a clearly articulated judicial framework, uncertainty may arise in the law. Such uncertainty affects not only the litigants before the court, but also Parliament, the executive, and every public institution that must order its affairs in accordance with the Constitution. The continued development of a coherent interpretative methodology, transparent, principled, and firmly anchored in the Constitution, will therefore remain one of the Supreme Court's most important responsibilities in the years ahead. For the rule of law requires not only that justice be done, but constitutional reasoning itself be sufficiently coherent, principled, and predictable to command public confidence. Ladies and gentlemen, perhaps the greatest constitutional responsibility awaiting the Supreme Court is the preservation of the delicate balance established by the framers of the Constitution and the smooth, harmonious transformation of this balance, the balance of equilibrium of the partners of government. Please, I reiterate, it's incumbent on all of us now to make sure that we assist the Supreme Court in reviewing this Constitution. The Constitution 1992 deliberately distributes public power among three independent arms. And I told you, the Parliament legislates, not the executive, but the executive president governs. I read some texts and they talk about the executive. Anyway, the executive power is defined by the same Constitution as the person in which it resides. And the same Constitution tells us it resides in the president. So when you are talking about the executive, you are not talking about ministers of state and the others. We are talking about one person, the president. And this has been compounded by the various parties. By the various parties. He is also the head of the parties. And he is the commander-in-chief of the Ghana Armed Forces. He appoints almost everybody, except those in Parliament. We are elected. We are not appointed. And so those of you who say that I've been appointed, please, you are getting it wrong. I was elected by your representatives. This is very important for constitutional review. If not, we have just dressed autocracy in constitutional ways. I won't say more. Let's accept that each arm of the government, as we know it, possesses democratic legitimacy. And these all contribute to the functioning of the Constitution. Each serves the same sovereign people. The success of Ghana's constitutional democracy has depended not upon the dominance of any one institution, but upon the disciplined observance of constitutional boundaries by all. And much of it has been held by the Supreme Court. Please, let this reflect unambiguously in the text of the Constitution. As constitutional disputes inevitably arise, the court will continue to play the indispensable role of constitutional umpire. In performing that role, judicial review should always be exercised with full appreciation of the constitutional functions, democratic legitimacy, and institutional competence of the other arms of government. Again, let me emphasize that institutional committee does not require constitutional deference, nor does it diminish judicial independence. Rather, it reflects the recognition that constitutional governance flourishes when every institution exercises its powers with restraint, when there is mutual respect, and when there is fidelity to the Constitution. The judiciary, parliament, and the executive are not constitutional rivals. They are constitutional partners in the service of the Republic, equal arms of government. My charge to the Supreme Court. Permit me, therefore, to conclude this forward-looking reflection with a respectful constitutional charge to the Supreme Court. I've been reminded that I've already used 1 hour 25 minutes. I assure you I won't use up to 2 hours. As you embark upon your next 150 years of service, please uphold the rule of law with courage and unwavering fidelity. You have a friend in me, and I will always come to your defense, even when your decisions are against me. Defend the supremacy of the Constitution without fear or favor. Ensure that judicial independence is captured in the text of the Constitution and matched by judicial excellence, consistency, and accountability to constitutional principle. Develop a jurisprudence that is intellectually rigorous, coherent, and accessible, one that provides certainty to citizens, guidance to public institutions, and confidence to future generations. Conform with a clear and deliberate intent to transform the delicate constitutional balance that has enabled the Fourth Republic to become Ghana's longest period of uninterrupted constitutional government, to constitutional equilibrium with the other partners in governance. Remember that every constitutional judgment speaks before the immediate parties, but beyond them, and speaks beyond also the court. Every judgment either strengthens or weakens public confidence in constitutional governance. Every judgment contributes to constitutional culture that future generations will inherit. Above all, ensure that every decision of the Supreme Court leaves the Constitution stronger than the court found it. History will not judge this great institution merely by the number of judgments it has delivered or the distinction of those who have adorned its bench. History will judge it by whether, when constitutional principle was tested, it remained faithful to the Constitution. Whether when the rule of law was challenged, it stood firm, and whether through its jurisprudence, it secured the future generations an enduring constitutional democracy founded upon Ghana's motto, freedom and justice. More importantly, the true measure of the Supreme Court's greatness will not simply be the quality of its judgments, but the confidence every Ghanaian has that justice will be done according to law. In the first 150 years, the Supreme Court established itself as one of the great institutions of our republic. May the next 150 years establish it among the world's most respected Supreme Courts, an institution whose jurisprudence continues to illuminate the path of constitutionalism, deepen public confidence in the administration of justice, and secure the democratic future of the Republic of Ghana. Congratulations to the Supreme Court of Ghana for the 150 years of distinguished service to the nation. May its next century and a half be marked by unwavering dedication to the Republic of Ghana. I now take comfort in the legal maxim, omnia praesumuntur rite esse acta. I thank you all for your attention.
Thank you so much, Honorable Speaker of Parliament, for the excellent delivery of the Supreme Court in the light of the 1992 Constitution, taking stock and looking forward. Let's appreciate him once more. Thank you. Please take your seat. We want to acknowledge the presence of the majority leader here, Honorable Mahama Ayariga. We understand the Honorable Speaker has another program. So at this point, we shall invite the chairperson to give the closing remarks, after which we shall take a few photos with the Honorable Speaker of Parliament and then continue with our program. Thank you. So we invite Justice Doche to give the closing.
I think you all agree with me that Right Honorable Speaker has gone to town with the topic. Let's give him 3 happy cheers. Hip, hip, hip. Hip, hip, hip. Hip, hip, hip. I think we have today been privileged to receive a lecture of learning, candor, and constitutional consequence. The Honorable Speaker has led us through 34 years in the life of the 1992 Constitution, showing how the Supreme Court has interpreted, defended, and given practical force to that charter, while reminding us with equal clarity of the continuing obligations that rest upon the judicial power. On behalf of all gathered here, I extend to you, Right Honorable Speaker, our sincere and profound gratitude. If there is one proposition I would ask us to carry from this hall, it is this: a constitution endures not merely because it is written, but because courts construe it with fidelity, restraint, courage, and reasoned authority, and because citizens uphold the rule of law as a common covenant. Across 150 years, and most especially in the 34 years since 1992, The court has borne that solemn mandate with distinction. It has done so through periods of difficulty and correction, yet with a constancy of purpose that has helped sustain the legitimacy of our constitutional order. That today's lecture calls us to take stock honestly and to look forward without complacency is itself a tribute to the maturity of our constitutional democracy. From the lecture, you all agree with me that we have a long way to go again. We can do better than we have done in the past 34 years. I also urge that with where he sits as the speaker, the poverty of the judiciary must come to an end with his intervention. He has identified a critical illness of the judiciary, and I urge him to be the surgeon and the physician to eradicate that disease. Right Honorable Speaker, my Lord the Chief Justice, my Lords of the Supreme Court, this lecture brings to a close the third in the series marking 150 years of the Supreme Court. The questions it has raised are not merely ceremonial. They go to the foundations of our constitutional interpretation, judicial responsibility, and public confidence in the administration of justice. I trust that the reflections shared here today will find space in our courtrooms, lecture halls, and public discourse in the days ahead. The Speaker has raised very tangible issues which we must continue. The Judicial Council, the General Legal Council, the Bar Association must all take something away from what the lecture has given us, and with a purpose of refining and solving and giving meaning to the issues raised by the Right Honorable Speaker. Thank you, and may you all travel safe to your homes. Let us rise and give him another round of applause. Thank you very much.
Thank you so much, Justice Doche. So we shall do the photographs in this order. Mr. Yakple, help us. Yes, so we'll have CJ, the Honorable Speaker of Parliament.
Kindly resume your seats, please. And we'll be out of here before you know it.
Any court.
Yes, so the regional minister is here. Please come forward. The Honorable Regional Minister, constitutional heads of constitutional bodies. Yes, Shraj, Electoral Commission, thank you. And the Majority Leader as a first set for the photography.
Meanwhile, we want to acknowledge the presence of the Justices of the Supreme Court. Just wave us, Justices of the Supreme Court.
Yeah. Please, the Justices of the Supreme Court, my lords, including retired Justices of the Supreme Court, please, it's your turn for the photography. Join the Honorable Speaker and my Lord, the Chief Justice. Please join for the photography now.
We also want to acknowledge the presence of the Justices of the Court of Appeal. You are welcome. Obake.
Please get ready to join for the photography, Justices of the Court of Appeal.
We also acknowledge the presence of the Justices of the High Court. If you are here, you are welcome.
Thank you, my lords. Justices of the Supreme Court, thank you very much. Justices of the Court of Appeal, please join for the photography. Thank you. We'll be done right now. Thank you. Thank you. Please come over here. Yes, 7 and retired. 7 and retired justices of the Court of Appeal. Thank you very much. Members of the Judicial Council, please. Members of the Judicial Council herein present, please join His Lordship Chief Justice and the Speaker of Parliament. Let's have that quickly. Members of the General Legal Council. General Legal Council. Members of the General Legal Council. Also,
we want to acknowledge the presence of justices of the High Court. You are welcome. And also judges of the Circuit Court and then magistrates. You are all welcome. Thank you.
thank you. Please indulge us. We have just about 2 more to finish. The Honorable Chief Justice and the Speaker of Parliament, kindly indulge us. Heads of security institutions and chiefs. Heads of security institutions and our revered chiefs. Please, it's your turn now. Heads of security institutions and our revered chiefs. Thank you. Ahoya. We shall now have deans of the various law faculties, law schools, deans. If the deans are here, please come up for the photography session. Deans. After that, we have the organizing committee, and that's where we end it. Organizing committee. Deans of the various faculties. The regional minister, please, you can take your seat. Thank you very much. Thank you very much. And thank you for indulging us. We understand that you have a very important program to attend to, but you stayed through. Please, members of the 150th Anniversary Planning Committee, get ready. It's your turn. Right. Thank you very much. Thank you. Now let's have members of the 150th Planning Committee. The very last group will be thank you very much. My lords in the High Court judges, serving and retired. Please, it's your turn. Please come up now. The Speaker and the Chief Justice keep standing. Please, High Court judges, serving and retired. It's your turn. High Court judges.
No. We have to make. We are done. We are almost done.
Yes, judges in the circuit courts, circuits, magistrates, directors, staff. Circuit, magistrates, directors, staff. Please, it's your turn now. Thank you very much. This session is done. This session is done. Kindly indulge us, the Honorable Speaker and the Honorable Chief Justice. After that, GBA. That's all. After that, the GBA. Please make room for the judges of the circuit courts, the magistrates and staff, directors and staff to join us. Thank you very much.
GBC News, your trusted news channel.
Meet the women who